And we are live. Hi, welcome to the Mission Mediation Podcast, created and produced by The Pact. My name is Jonathan, and together with my co-host today, Nisshant, we welcome you to the first episode titled Are Mediators Actually Mediating? So Nisshant and I have been into the field of mediation for the last 8 to 10 years. We don't quite know when the birthday of Pact is. It's similar to my grandmother's birthday. I never knew how old she was or when she was born. But we think it's around 8 to 10 years old now. So we've been around for the last 8 to 10 years, plowing the fields for mediation in India. We've had the privilege to have worked with so many fantastic mediators, lawyers, judges, students, taking forward this mediation movement in India. And today is birthing a special new venture here. And we've got two special guests with us, which I'm dying to introduce to you. But I'm going to get to that very, very soon. But the Pact has had the privilege to be a part of the Indian mediation movement for the last 8-10 years. We've worked with over 16,000 young lawyers, acquainting them with the knowledge and skills of mediation. We've created platforms, conferences, trainings, awards, competitions for aspiring mediators and aspiring mediation lawyers to rub shoulders with some professionals out there. We've been developing conversations as well on the marketing, branding, and business of mediation, something that many of us back in India are a little shy to talk about, but we've not shied away from talking about that for quite some time. And this venture, this Mission Mediation Podcast is taking that forward, taking that approach forward to talk about mediation branding, mediation marketing, mediation practice, how you sustain the practice in the mediation space. Our focus over the last 3-4 years has been mediation advocacy, the role of a lawyer in mediation. We have had the privilege of training dozens of lawyers, those functioning independently in chamber practice or as an in-house counsel or as corporate or disputes lawyers. And India might have a mediation law now, but it's the mediation lawyers who will take forward the practice in India. So today's focus obviously is not on the mediation lawyer, but on the mediator. And we will come to the mediation lawyer as we go down with this podcast in a series of different episodes to follow. We will be touching upon the role of the mediation lawyer. But today, it's all about the mediator. Are mediators actually mediating? I know this was a provocative question and yet reflective. And we wanted you all to start talking about this topic and say, why have they framed it that way? We know for a fact that there are thousands of trained mediators in India, but almost all sustaining themselves from court annexed mediations. And we want to change that. So starting today, we hope to inspire mediators in the mediation community in India and beyond to look at mediation as a full-time profession. And we got two folks who took that big call a decade ago, maybe more than a decade ago, to say they're going to pause on their law practice, pause on their lawyering practice, and be full-time mediators. We got Bill Marsh and Chitra Narayan, two of the finest mediators joining us today. Now, if I start introducing them, then it's going to take forever, so I'm going to keep it short. Bill is an independent international mediator based in London and the owner of Independent Mediators Limited. We don't have too many minutes to list out the number of times he has been awarded Global Mediator of the Year. But just last year, he was recognized as a Global Elite Mediation Thought Leader for 2024. Bill mediates national and international disputes to date involving governments, businesses, organizations from over 50 countries. These include commercial disputes, of course, and also environmental, religious, and political conflicts. Bill is also the editor of the Kluwer Mediation blog. So if you want to know what's going on in that mediator's mind, go check out Kluwer Mediation blog. Bill, thank you so much for joining us from London today. Next up, I will introduce you to Chitra Narayan. Chitra is a lawyer and senior mediator with over 25 years of experience. She's a founding trustee of the Foundation for Comprehensive Dispute Resolution, FCDR, a Chevening Scholar and a Weinstein Fellow. She has been part of the Tamil Nadu Mediation and Conciliation Center since its inception in 2005. She was a member of a group of mediators appointed by the Mediation and Conciliation Project Committee of the Supreme Court of India to draft a legislation for mediation in India a couple of years ago. And she's, of course, the author of Mediation Policy and Practice. Now, if you're not following Chitra and Bill online on LinkedIn, please go do that. You'll see a clicker at the bottom of your screen throughout this podcast, which will share with you a lot of details about where you can find more information about the speakers, more information about PACT and what we do. So look out for that clicker at the bottom of your screen and engage with us. This is, of course, live. on LinkedIn and YouTube now. So if you're joining us live on LinkedIn and YouTube, say hello, join in the conversation, drop your comments, drop your opinions, drop your suggestions. You don't have to agree with what myself or Nisshant or Bill or Chitra are saying on this conversation. You can disagree with us. And we'll try and address some of those comments that are coming in on LinkedIn. So wherever you're joining us from, drop in a hello and be part of this fantastic conversation today. Having said all that, I'm going to stop blabbing now and actually start the conversation. Are mediators actually mediating, Bill?
Well, the short answer in my personal case is yes, and in the case of many of my colleagues here. This is my 35th year of being involved in mediation full-time. So if you want any indication that it's a sustainable business and a place to earn a living, certainly in this country, then that's the case. And there's no reason in principle why that shouldn't be the case in India as well. Just one comment that really interests me is the amount of people signing up to address this question, which is part of which is the gap between aspiration and practice. And it's very striking that so many people are interested in that. I think it speaks to the fact that mediation interests people not just in the head, but in the heart as well. There is a sort of what I would call a passion gap between aspiration and reality for many people. And hopefully we can address some of that passion gap today.
Chitra?
When I saw the topic, two thoughts popped in my mind. The first is, are we mediating enough, or are all the mediators getting to mediate? And that's an aspect that Bill has touched upon. In India, we certainly are not mediating enough. And I think you did mention possibly the tens and thousands of mediators trained in India who don't get enough work, and a lot of them, I think, are very nervous and anxious about committing to a full-time, mediation, and always need to fall back on something else. The second aspect is how are we mediating? What is happening in those rooms, big and small, when we mediate? And I think with 20 years of the mediation, the Court Annexed Mediation Center being set up in India, the first, which was in the Madras High Court, as well as 30 years of private mediation, which was, enabled through the Arbitration Conciliation Act. It certainly is time for reflection to see what we're doing, how we're doing, where are we doing, and where do we go from here. And I think that's important for us in India at this time. Those were my responses.
So a pragmatic start. I hear times for reflection, but also time to get into action. It's time now. The time is ripe. We have plowed the fields, and I'm really excited about this. So the focus today, before Nisshant takes over, the focus today is on three major questions. We're going to hear from Bill and Chitra about a mediation that has really inspired them. One of the latest mediations has really inspired them. The second part is where we talk about how they created and developed their career as full-time mediators. And thirdly, towards the end, we'll talk about how we can build an ecosystem for all mediators to actually flourish. Over to you, Nisshant. You're on mute. Sorry.
Thank you. So thank you, Jonathan. Bill and Chitra, we do understand that, you both have been mediating for a while. Bill said that in the UK, mediation has picked up. It's been 35 years for him, and a lot of his colleagues are mediating, whereas Chitra said she has been mediating over the last 20 years. But there's a lot more work that needs to be done to fill the gap. So, we've always seen that success stories in mediation, because mediation is a confidential process, the success stories don't come out as easily. And that's what I'd like to focus here in the first part, that if you can let us know of a mediation that you did, and so if you can let us know the facts of the mediation, and then I'd love to break it down for the viewers to know the process that you underwent with regards to that mediation. So maybe Bill, if we can start with you first, if you can share a set of facts of a mediation that you enjoyed, and would then love to take the viewers through learnings and the preparation stage.
Yeah, okay. And I think I've got 6 minutes for this, so I'll speak speedily. Or succinctly, perhaps, is a better way of doing it. Look, I've chosen a particular mediation. It's very recent. It's on a particularly large scale. And the reason I've chosen it is because, frankly speaking, if mediation can work at that level, then it can work at almost any level. And so that's the reason I've chosen it. The fact of the mediation is in the public domain. Obviously, the details of discussions are confidential, and I will stick, of course, to what is in the public domain. So some years ago, here in London, we had a big fire in a residential building. It had recently been refurbished, and the problem was that the material on the outside of the 23-story building was too flammable. A fire occurred in the flat on the fourth floor, one of the flats on the fourth floor, at the back of a fridge, and very quickly the entire building was in flames. 72 people died, thousands of people were traumatized. There are horrific stories of people, for example, mothers and fathers talking to their children, and the parent is maybe with a relative at the bottom of the tower. Their children are at the top of the tower and they can't reach them. And then the phone goes dead, and that's the last they see of them. So this is trauma on a huge scale. Over 1,000 individuals and families brought claims through the courts, and they brought them against many defendants: the building owners, the people who refurbished it, the government for the regulatory system, the manufacturers of the cladding, the architects, the fire safety people, also the fire brigade, because, again, this is public knowledge, the fire brigade, thinking it was the right thing to do, issued a stay put order so that everybody who phoned from the building to the fire service was told to stay where they are, and the firemen will get to you shortly. After 2 hours, it became apparent that the stay put order was not the right way to go, but then it was too late for people to leave. So that you can imagine the level of trauma. There was, I think, between 25 and 30 law firms involved. And the background to it as well is there was a statutory inquiry, a public inquiry, to allocate blame, and also investigations into criminal proceedings. So that's the context very quickly. Do you want me to say a little bit about lessons learned of the process?
Sure. So, but even before the lessons learned of the process, I'd like to know from you. You mentioned that there were about 25 to 30 law firms. There was public inquiry that was commissioned. In such a situation, when there are multiple stakeholders, that is the victims in this scenario, then you have the government, then you have the state that's involved, then you have lawyers. How do you prepare as a mediator? And then, of course, we can go into the learnings and the challenges, but how do you prepare in such a situation?
Yeah, thank you, Nisshant. I mean, this is not your average mediation where you turn up for a day or two and have some negotiations and go home. This is a multi-year process. How do you prepare? I mean, as you start all mediations, you have to go and meet people. And I should say, and I'll say a bit more later, but I have spent hundreds of hours in cafes and community centres in that part of London talking to traumatized families, because they wanted to know who the mediator is, and they want fundamentally to tell their story. That's what I found in this context. So the preparation was partly about getting across the legal issues, which are hugely complex, and partly about building trust, which is about meeting people and just spending time listening and not pretending that you understand what they've gone through, because you can't possibly. You imagine the phone call between a mother and a daughter, and that phone call is then the last they ever speak, because the phone is cut dead, because the fire reaches that story. I mean, you can't. So it's just about being available for people to build trust at a very human level.
And then in such a situation, of course, you've gone through the process of empathizing with them, trying your best to put yourself in their shoes. What were the challenges that you faced in this mediation?
I picked out three, I think. First is that a good process, any mediator will tell you, a good process is vital. It took us nearly a year to negotiate the process because there was so much concern and skepticism and fear about what might be involved. But the point about that is once you've invested in a process that everybody buys into, you've got then a real commitment to it, and it's much easier to deliver the process. So I would always say, I do always say to mediators, you can't shortchange people on trust, which is building relationships, and on agreeing an effective process. If you get those two in place, then all sorts of things will happen. The second thing is numbers, because obviously here we had more than 1,000 families and individuals who want to, and you have to give people a sense of participation. So how do you give that many people a sense that they are participating properly in a process? That's partly about the time I spent just talking to families. And my fellow mediator, I should say, I was a co-mediator with me as well. So there was my fellow mediator. It's partly sorting out decision-making systems, because how does a deal done in a room where there are obviously not 1,500 people present, how does that deal filter down and people buy in meaningfully? So that was part of it, the challenge of numbers. And then I think the third thing, which is really illustrative for me of a lot about mediation, is the nature of the resolution. And again, this is public knowledge, so I can say this. There are three components to the resolution. One, as you would expect, is compensation. So each injured person, each bereaved family and so on gets compensation. The second is what's called a restorative justice fund. And that the defendants have contributed more than 50 million to that. That is now a fund which is available for the community to use. And for example, many children missed out on their education because for 2 or 3 years, they were too traumatized to go back to school. So the fund will fill in that educational gap. Some people the one girl I met wanted to become a doctor, but she was too traumatized to continue her studies, so she didn't get her exams. So the fund now has enabled her to redo her exams and get a place at medical school. That's just an example of a very personalized thing. The fund also funds counseling for people in the community, because the whole community was affected. And it funds something called a memory project. So it was extremely important to they call themselves the victims, the people who were hurt, extremely important to them that their experiences were memorialized in some meaningful, permanent way, and that the lessons learned were learned by the construction industry. So there is a whole project, a multi-million-pound, multi-year project funded, in which the lessons are learned and the experiences of the people concerned will go into a permanent exhibition. The third aspect was something called Testimony Week. At least that's the name I gave it. I said earlier on, people need to tell their stories. So this was a whole week in which the claimants themselves, anyone who wanted to, could attend in the presence of senior representatives from all the defendants. So we had government ministers and chief executives and everybody else. And for a week, they could say whatever they wanted. They could read a poem. Many of them showed photos and played videos of their lost loved ones, their children or friends or uncles and aunts and so on. And they told their story. And that sense of witness to their trauma was central. Now, we often talk about that in mediation, where in a more typical mediation, people have an opportunity to tell their story in the presence of the other parties. We couldn't do that in a typical way, so we hired a building for a whole week and made that available in a different way. But it speaks to the points that mediations, if you don't make a space for people to tell their story, you've made it much harder for yourself. So I picked those three quick lessons.
So I think the 3 points, or actually the 5 points that come out for me from a mediator standpoint. Number one, the preparatory stage, as you mentioned, is very, very important to be meeting the parties involved, communicating with them, and understanding what their concerns and issues are. Right? Because I know at least in India, we a lot of places we end up starting with the joint session. But what you're saying, that no, there is an important stage, that's the prior to the mediation, where you're going communicating, connecting with the people. Then the process is important. We need to come to an agreement on the process that we're going to be following for the mediation. The numbers and a decision-making system is important, and finally, the nature of the resolution is something that's important, especially in your case. And I think, Bill, this goes for many mediations, that we do, and I'm going to come back to you on that. But Chitra,
Nisshant, if I can just come.
Sure, go ahead,
Nisshant, if I can just quickly, I just want to ask Bill one question that's just lingering on in my head. How did we get them to mediate? Was it referred by the courts? Because something like that, this is massive, where the first thought that comes to your head is retribution, that someone needs to be punished for this. This cannot be just ignored and by compensation monetarily, or by by restorative justice. Someone needs to be punished. That's the first thing that you're thinking about when you're reading the news. So how do you get so many stakeholders to say yes to mediation?
Okay, the first simple answer to that is that they had very sophisticated law firms involved who could see that there was an obvious benefit in resolving this on both sides. The second is that when people come to you in a process like that, the first thing everybody said to me on the claimant side, we want justice. Mm-hmm. And so I had to say to them, what does justice mean to you? And the first thing they say is, we want those people in prison.
Right.
Or worse. And then you have to say, look, mediation cannot deliver that for you. This is what mediation can do. This is what it cannot do. Is there enough in this one for you to think you might want to be involved? And you give people a very honest, very clear choice.
Yeah. Awesome. Thanks, Bill. Thank you so much for that. Nisshant, back to you.
Yes, thank you. Chitra, over to you. What has been one of your memorable mediations? Would love to know the facts, of course, within the realm of confidentiality, and then would love to go through the process.
Thank you, Nisshant. The one I've chosen, there are, I think, about 4 or 5 that are memorable. The one I've chosen is a family business dispute that I mediated recently. The family was in the hospitality business, 3 generations, 4 groups of families, and businesses in more than one place, a lot of properties that were involved, and a huge amount of mistrust, anger, hurt, a sense of alienation. There were events, small and big, that had, caused a lot of outrage. Some very, very small issues, really small issues, that had sort of, caused a lot of alienation amongst all 4. It's not that there was, a bunch of two families against 2 or 3 against 1. It was all 4 that had issues with all the others. Each of them had issues with the others, and these alienations had caused the businesses to be pulled in different directions. The one family was doing something, the other was doing something else, all under the same umbrella of the business. So they were pulling things apart. One then wanted to, just shut it all down. Though it was a very valuable business, very well-known hospitality business. And this is how they came into mediation. So you had 3 generations actually sitting at the table, angry, hurt, hadn't spoken with each other except possibly at social gatherings, but nothing more than that. They knew they had a lot that they wanted to sort of get from the other families. A lot they wanted to sort of square off and get answers for, but had never really managed to do that except by litigating. So this, is the background to the dispute.
Okay. Yes, I think when there is no communication, it tends to kind of escalate the entire situation, whereas the need of the hour is to communicate. So in such a situation where the parties haven't spoken or are not willing to speak to each other, how do you then prepare? Because I know Bill said that, okay, he spoke to each one of them individually. How do you prepare and understand them and then convince them to come to the table?
Yeah, so here I actually had a first session with just the lawyers, and they were fresh from proceedings in court, and the first session with the lawyers, where I tried to get information from them about what it was, a little more information about the disputes. It was shrill, it was adversarial, people interrupting each other and saying, no, that's not right, this is what it is, etc., etc. And I did spend this first session going over the mediation process with them. How it's different from litigation, how we're not here to sort of set up, this is my entitlement, this is my right, this is where someone is wrong, and this is how I am blameless. But, how do we work to collaborate to see what our long-term interests in this are? And once, we had done that, and then we scheduled a meeting with the parties. And as a preparation for this meeting, I requested the lawyers to talk to their clients about what to expect from this process, and how this process would work, and in identifying where their interests lay. So this was an exercise, possibly not an exercise that could have been done in one go. But when we had our first meeting as 4 families together with the lawyers, I went through what the mediation process would be, what they could expect, the different stages, how it was to flow. And I also had the lawyers supporting me, probably adding value to how I was conveying what the process was. So that helped, because there are many parties, lots of moving parts that I would anticipate, and, we did have it that way. Sort of reining in expectations, reframing sort of or resetting expectations from the process and from what they could get out of it helped.
I think having supporting lawyers in a mediation is a blessing for mediators, for sure. There are no two ways about that. Because ultimately, when we fall sick, we end up going to a doctor, right? And when there's conflict, the first person that a client or a party in conflict goes to a lawyer, not a mediator, which is where I feel that if the first touch point is the lawyer, then the lawyers need to put forth, mediation before their clients. So now that we've reached the stage where, okay, we got the people to the table, I'm sure the lawyers would have done their bit in kind of getting the parties to the table of mediation. How did you earn the trust of the parties once they came onto the table? Because they're not, willing to speak with each other at all. And what were your biggest challenges?
I think the way to earn their trust was listening. So they repeated themselves. Some of the things that seemed childish, that was something that had happened many years ago when they were much younger, had its space to be expressed. Repeating this at various stages of the mediation, but then, this is what happened about that. Though it wasn't important in the long term, and it was a small incident, just letting them speak, attempting to understand how important that was to them. That, so I think,
when they were talking, were they, as in when they were expressing themselves, were all of them together in the same room, or this was individual?
So here's the thing. After the initial group sort of getting together, I mean, people were sort of very, very hostile, a lot of vicious language. And so we did speak with them individually in private groups. So 4 groups, and we did speak with them then. And it gives, I understood again how important the private session can be. And this was a space where they could be as vicious as they wish to be, as sort of extended about the various things that they want to talk about, how as intense as they wish to be, about what had happened. And so we then moved to the group, because I thought it was important that everyone sit together and we talk moving forward. Some of this emotion was spent. They felt heard. When they came together, it was important because each of the persons were visibly seeing the others engaged in this process, were visibly seeing each of them sort of helping to identify the issues. What is it that they wanted, explaining their expectations, why, justifying their expectations. So the use of the private and the joint session serve their own purposes. And I think private sessions are important, but they should be used tactically. For a family like this that had gone through so much together, and where there was so much in terms of information asymmetry, participation asymmetry, it was good for them to listen to each other, which helped, get the conversation going from the past to, what
the
next.
future.
Yeah.
No, so in this, then I do understand your one of the biggest challenges was, of course, listening, because one is, of course, to listen, but then we're also saying you as a mediator also have to actively listen for that amount of time, which I do feel is challenging, but it only comes with practice. So what was your biggest learning or learnings from this entire mediation? Because there were multiple stakeholders, multiple emotions, everyone had a different angle of the same story.
So I probably tell you what happened thereafter. There were 4 big issues that they had identified, and they were settled. The first 3 were settled, even in terms of specifics. The 4th required a little more. It was agreed on in principle, but it needed sort of interventions or value additions from chartered accountants, from valuers, from surveyors. And while these discussions and these reports were coming in, and we were, looking at various options on how things could be done. And as you can guess, it was on the division of the business, because that's what they all agreed they wanted to do. And so while this was going on, one of the families took a particular decision, of a series of steps relating to the business, which, because of the way it was organized at that point in time, they had, the ability to control and take that decision. They took these decisions, and I guess they felt that it was very opportune, but the others didn't agree. And I think the fact that this decision was taken by them while they were in mediation, and when everyone had invested so much of time, so much of energy, money, in getting advisors and others to sort of, weigh in on how they could settle, and of course invested trust. Beyond a point, they'd said, we know we can work together and sort this out. So when this happened, it came apart completely. And so we didn't have a settlement at the end of it. Though we had an agreement in principle on all the aspects, we didn't have a settlement because a couple of the families felt that it was a huge betrayal. And, they had crossed this psychological hump, begun discussing, had gotten into what it is they were going to do, and then suddenly this happens. So they felt this was a big betrayal, and they, try as I might, we still had several sessions to see what we could do about this. They were unable to sort of come back to the same space that they were in. And so it didn't settle. So the lesson there is on, I don't know, possibly while businesses are running, while actions are taken, while decisions are taken, that we also keep a lot of forward-looking aspects in the conversation as mediators. Try and understand from them what's happening with each of their activities, in running these businesses. Keep that conversation also going. Reinforce how this is going to be joint decisions going forward. So this is sort of, I think, an important learning from me, for me.
I just want to come in there, Nisshant. I know that we are quite eager to move into our second segment as well. This is two fantastic stories to kick off the Mission Mediation podcast, right? I wasn't expecting us to be discussing multi-stakeholder disputes right up front there, because when we think about mediation, and even when we do mediator training, it's always one party, this party A and this party B, and we as mediators come and try and resolve that, right? And this is fantastic to see. Commercial mediation taking place in a space where there are multiple stakeholders. There's so many interests involved, so many backgrounds. The positive that I'm taking out of this is that how the lawyers and the law firms involved, both Bill's story and as well in yours, Chitra, how they played a crucial part in kind of leading the party's mindset shift, to move from a retributive, mindset into that collaborative mindset. To move from justice to collaborative justice. Someone asked me, how can you get justice in mediation? And I was like, you can, but you're also looking out for justice for the other person. So the win-win, it's easier said than done. We use that word quite a lot. I have just a very quick question, Nisshant, if I may just get in here, because in both these places, there were multiple stakeholders involved. There were so many people, different cultural context, I'm sure, as well. How did you explain your role to them, like who you were? Because they would have come across lawyers, judges, probably counselors, therapists in your case, Bill, because it was something to do with post-trauma as well. So how did you stand out to them? Because you were suddenly a new kind of character into this dispute that they were going through their lives, right? And so how did you introduce yourself to them, and who you were and what your role was and what your limitations were? If you could just quickly kind of touch upon that, please.
Good.
Oh, sorry, I thought you were coming to Chitra first.
I
mean, for me, the central role really for mediators is to try to enable people to make good decisions. And I think if you put it that way, I mean, I've never come across anybody who doesn't want to make a good decision. So it's kind of self-evident. And there are hurdles to get over in order to make a good decision. But I find that the basics really of treating people with dignity and respect, listening, Chitra mentioned listening. I mean, you can't over listen really when people have got stuff they want to say to you. And I think the other point really is about, and again, you've touched on it, Chitra, as well. It is about how we work with the legal profession. And I do worry that sometimes when mediation is developing, it gets a kind of anti-lawyer feel, and nothing could be further from the reality. That lawyers are often central to these processes working well.
Yeah, agreed. Chitra?
I explain the process and I tell them, variously, that I'm a friend, that I'm here to just help you. I'm here to assist. I'm here to support. And I don't think the realization comes in immediately. I think it comes in a few meetings later. The penny drops. And, they realize that they're the persons taking this process. And I'm here just to manage, sort of just behind the scenes, sort of navigating, the rooms, or how big the room is going to be, things like that. So they do realize then that, it's in their hands. So it doesn't happen immediately usually, no.
But you don't expect a friend to charge, right? You don't expect a friend to charge. That's my fear in mediation in India. The moment they say I'm your friend, then they'll be like, hey, why did you send me an invoice as well? So yeah. On that note, I think Nisshant has got something for us.
Yes. So, Bill, you mentioned that you have been mediating over the last 35 years. Your colleagues are mediating. So UK seems to be a developed jurisdiction in terms of mediation. And of course, Chitra, we know in India, we are in the stage where it is developing, and there is mediation happening, but there's a lot more to be done. I want to know from you both, at what point, right? Do you actually remember the point when you decided that, okay, I now want to switch into mediation? Bill, in your case, you left litigation completely and are into mediation. What was that point or instance where you made that switch? And then, of course, would love to know how you kind of built the practice and developed on it.
Gosh, I mean, I suppose I'm not sure there was a particular point. If there was, it was probably sitting in a lengthy meeting as a young corporate lawyer, with arguments going to and fro across the table, and asking myself whether I wanted to spend the next 40 years doing this. And as soon as I asked that question, I knew the answer. And then, from there, stuff happened. I think the first thing I'd say actually about getting into mediation is that it is a deep privilege. And if you don't think of it as a privilege, I think I wouldn't say it's a problem, but it shows. I mean, if we do think of it as a privilege, it shows, I think, in what we do and how we conduct ourselves. It's a privilege, perhaps not a right. I started in the UK when there was little or no mediation going on. So a lot of our work was to do with building an intellectual and maybe an ethical case for mediation, as well as a pragmatic one. I think first of all, for those who want to go down this route, it's not easy. You've got to have a real sense of purpose and commitment to it, and really want to make it happen. I think how we sell ourselves is absolutely central. I guess it's quite a personal thing, but I find quite often that when I look at how some mediators sell themselves, it seems quite marketing orientated, if I can call it that. And I don't mean that unkindly at all. Everybody's different, and we all go about life differently. But I think for me, conveying a sense of integrity and honesty is central to what we're presenting to people. But I mean, I think people look at, I wrote a blog actually on warmth and competence, because I come across this notion that if you have 2 minutes in a lift wall, you form a quick impression of people, or people form it of us in a very quick time. What they're looking for in a professional context is two things. One is warmth, which is basically, can I trust you? And the other is competence, which is, can you deal with this in a way that is worth paying for? And so I think when we come to developing ourselves as mediators, those two are very important. And I think actually it's incumbent on us as mediators to be good. And I know that sounds odd, but sometimes the whole debate around mediation descends into, well, they whoever they are, the sort of the client base out there somewhere, should understand how good this is for them, as if we're selling vitamins. And I'm a bit troubled by that. I think actually the pressure is on us to be really, really good at what we do. And then I think the more we can emphasize, the more we can work on our own ability, the better. I mean, I could say lots of other things, but we're short of time.
Just a follow-up question on that. You mentioned that, okay, I do understand that the onus is on us as mediators to kind of provide an experience of conflict resolution through a process that the parties at the end of it feel that, okay, they gain something out of the entire process vis-a-vis the other mechanisms of dispute resolution. But my question is that happens when they come onto the table, right? What do you do and this is a question I'm going to be posing to Chitra as well. What do you do prior to that? Because in court cases, it is being published somewhere. Like in India, we have Manu Patra, we have SEC, that are platforms where these cases are published. Whereas mediation, being confidential, is not published. So how do you put yourself out there? Because only when you put yourself out there and people know you're doing this, will they come, and then of course you can present your ability. So how do you kind of do that?
I mean, there are lots of ways. You can write articles, you can speak at conferences, and we've all done the sort of conference circuit and the article circuit. But I think fundamentally, when we speak or write, what people are looking for is inherent value. What are we actually saying? And I think if the more it comes across like we're selling vitamins, if it was me as a client, the less I would be interested. So I think we have to have the onus is on us to have really serious things to say about the nature of conflict and the nature of dialogue, and not just, I think selling a process is important as well, but it's not just about that. It's the underlying thoughtful, intellectual contribution that we're making to the whole field that I think is what promotes us as well.
Fair. I'm in complete agreement of that. Yes, not selling only mediation, but also the underlying elements of it. And I think it's about making it a part of your regular conversations with whoever you come across. And so Chitra, this is where we come in as well. How did you develop your career in the space of mediation? And do you remember that time when you made that switch, or you said, this is what I want to do as a major part of my practice?
I think that moment was when I trained in mediation, and I said, it was really a huge moment for me when I knew that there is this way, to resolve disputes. I have a lot of shame, a lot of misgivings about being a part of the mainstream litigation system. And so this was a big thing. So I knew I wanted to do this. And I think some years down the line, I decided that this is all I want to do. I don't want to, do mainstream practice anymore. But I did take the step only when I was certain. I was a partner in a law firm, in a national law firm, and I did it when I had built enough to be able to sustain myself without earning for a little while. I was fortunate to make that choice. I think I know many people who are passionate about mediation but can't take that step. So I think that was, I was lucky. Initially, I'm not someone who can do the 2-minute elevator pitches and, things like that. Like Bill says, there is so much to be said about this that it's not something you can sell. And so I did build the talking wherever I could about mediation at conferences, which were fairly new at that time. I also started writing about it, blogs and newspaper articles, very short articles. My husband advised me very early on that you need to pitch this very simply, succinctly, in short form, for more people to, come to know about this. I have to say a lot of my work then and now comes from quote and next mediation. And so the things I did in order to sort of keep this going was to start working. At that time, I felt we needed a law on mediation. So I started working on a law on mediation, read up, spoke to people. There were others who were interested in the similar thing. And actually, it thrills my, I'm delighted when I see some language that I had, which is in the Mediation Act. So that was something that took a lot of time. There were a lot of people who were, who felt the same. And there was a lot of effort, and that kept the energies going. The Weinstein Fellowship did a huge thing to keep it going, because you were surrounded by mediators and all you were listening to was this, and that reinforces what you want to do. I'm also part of a group called the FCDR. Jonathan mentioned that, and as a group we did work as well. We had conferences on mediation, efforts at mediation advocacy, training, and we've also worked with universities on mediation. And we've created a support group in Chennai. It's not been very sustained, but we used to have breakfast meetings where we would talk about our work and issues that came up. So this was worked through FCDR. But I have to say that at some point in time, I realized I needed to do more than just wait. And so I've started teaching part-time as well as doing arbitrations. That's a small part of what I do, but I do that, and that's how I've managed to sustain the work. Now, for all the efforts that have come, and as well as the Mediation Act, there are lawyers who look at mediation as a way in which their clients can resolve their disputes. But this has been my journey. And no less.
Nisshant or Jonathan, can I pick up on one point Chitra made? In fact, about writing. I have a phrase that I say to new mediators when I come across them, which is, don't wait for the phone to ring. And they look blank and say, yeah, but I mean, what does that even involve? So just one example of writing. So I'm a member of the Church of England. I say a member, I mean, I go to church on Sundays, that sort of member. I have no role in it. About more than 10 years ago, the church was having a huge fight about whether women could become bishops. And this was a really deep issue of belief on both sides of that divide. And they'd voted on it many times, and it was chaos. So I wrote a paper just looking at the current process of trying to resolve it and asking slightly provocative questions. And I wrote it actually for my own benefit, because I just wanted to get my thinking clear. Sent it to a few friends. One of them I knew at the time, actually, but one of them worked for the Archbishop, and she said, can I give a copy to the Archbishop? It ended up on his desk, and a week later the phone rang. And I then entered a mediation process with the National Church for whether women could become bishops. And as a result of that, agreement was reached, and a new vote was put to the Church's Parliament, and they can now become bishops. So I mention it just as part of the story. Somebody had to say in writing, I wonder if something better is possible. I don't know, I'm just a mediator, but I wonder. And if anybody out there is interested in exploring it, maybe we should talk. And I think it's that kind of initiating. And of course, if you approach it that way, you'll find conflict in every corner of every society, which can be approached. And it's not a question of saying, hey, you people, I can sell you a mediation and we could find a deal here. I think it's much more nuanced than that. It's much more about saying, when I observe this situation as someone who spends their time resolving conflict, this is what I see. And it doesn't surprise me, but I wonder if anybody involved would like to talk about how you might do it differently. So that's an approach I've used in many different cases as well for getting involved. So it's an example of Chitra's point about writing.
I like that. I like the point of getting involved without getting involved. So you're making a point that you're saying that there is that space for that, for a neutral kind of conversation where you don't have to take sides, but you're here as someone who can listen in and kind of just help them with questions. So I guess I would love to read that, by the way, Bill. I don't think I have read that yet, but just to understand how you put that out there, to kind of just pose the question in their minds, to say there is something else. There is a third view available here, which is not judgmental at all. And I would really like to see and read more about this. I just want to take Chitra, were you about to say something, or I just want to take a step back from the question?
There was this other effort I took to sort of stir the pot a bit. I conducted a survey with general counsels of companies to find out if they used mediation. What did they think of it? Did they use it? Would they use it? of course, I wanted to know what was happening. But I also wanted them now to, because they had to answer this questionnaire, to think about or to find out more about mediation. And that's the results are there in my book that I wrote. So I use this time to write as well. But what came out from there is that there were misconceptions about mediation. And the second thing that GCs felt was that it was a small group, so I can't generalize, but what they felt was that mediators must have subject matter expertise. That for them would give them credibility with the mediator and with the process. So learnings along the way as we.
Yeah. There's some good questions coming there. We'll see if we can touch upon some of them a little later. I just want to kind of put this out there. This sounds like a real trivial question, but I still want to put it out there because it's here where we are struggling in some way in jurisdictions which are not so familiar with mediation. I think it's about getting the parties to the table, right? It's about them seeing the value in you as a mediator. And a lot of times, and I know that you all are both in a better place now, Bill and Chitra, but if you can go back, flashback to 10, 15, 20 years back when you were starting out and when you were pitching yourself as a mediator who's going to charge for their services, did you find pushback? Did you feel pushback in the parties to say, listen, the law is already charging us, so are the courts, so is everyone, so are the investigators who I've hired. And you're coming in here, and at the same time, you're saying, listen, I'm not going to find you a solution. You've got to find it yourself. I'm going to just help you with creating the best environment and asking the right questions and all that stuff. And did you find that pushback when you were saying, listen, you've got to pay me for all this?
I mean, I actually think the reverse is more important, if I can put it that way, that I think too often mediators do things for free and because we want to get experience and all the rest of it. And I understand that. But actually, the reality then is we are ourselves devaluing what we offer. I think there is a deep value in what we offer. And it's partly that we have to have the confidence to do that. And I think, too, when you're presenting mediation, for example, to a client, you're selling two things. One is the process and the other is yourself. And those are quite different. Selling if selling is the right word, presenting the process, it is in one sense not difficult because it's working very happily all over the world. So there are plenty of examples of it. There may or may not be in that particular client's experience, but it's going on all over the place. And yourself, I think that's, it's not easy, of course, because everybody says, like when you go to a surgeon, you don't want that surgeon to be doing that operation for the first time. I mean, or an airline. Right. This is the first time I've flown a jumbo jet. Well, thank you very much. I'll go by a different airline. So there is that inevitable problem, but you can't get past it. I mean, that's just part of life. Everybody has to do something for the first time. So I wouldn't spend much time worrying about that.
Yeah, I love the analogy of having a co-pilot. I mean, we would be scared if we knew our pilot was flying for the first time. But there's a process to that, right? They go through their own. They'll have, I'm sure, a lot of times when they just observe and they're co-piloting, and then finally they become pilots, first officers and pilots. So I guess when mediators go solo and expect the parties to just surrender all their troubles to them, that is quite a concerning thought. Just like I'm thinking about it right now. But Chitra, over to you on that same question about any pushback when you pitch yourself as a mediator.
No, I think the way it worked was, they're not. This is something new that they're looking at. They're invested in litigation. They're invested in adversarial processes, and you want them to try this. And so, because you want them to try it, and you want them to see, to realize the value of this process, you understand. You say, I will do it for so much, which you think would be something that they'd have an appetite for. The second thing is that unlike litigation arbitration where there is an outcome, whether it works for you or it doesn't work for you. There's an outcome, and here there may not be an outcome. The clients are conscious of that, the parties are conscious of that, and so are you. That's another factor that works in them being willing to pay. But I think now it is, mediation, I think there is a greater awareness of mediation, and people are willing to pay, particularly people who can afford to pay that, not small, matrimonial disputes where parties have very little net worth. Other people who are able to afford are willing to pay, for these services. And I think when they pay is when they see value, that they must give this process their best to see that they get an outcome here. So I think no pushback anymore.
I agree on that. And I think Nisshant and I will also agree that people have slowly started to knock on the doors. Lawyers have slowly started to inquire, send in those emails, make those calls, tell us more about your process, tell us more about your structure, tell us more about how you're billing. And in fact, just a couple of weeks ago, I tried something different. I said, I'm sure you've spent a lot in arbitration already. If you had to see, if I would just simply ask you a very trivial question, what's your budget for mediation? What would it be? Right? And it kind of took them off guard because they didn't have an answer to it. I said, you don't have to answer that now. You can go back to your team, you can go back to your disputes team, speak to the managing partner and say, what's your budget for mediation? Because they always ask us for what it is. And instead of kind of, I would say, facing that pushback straight away, I would say, what's your budget? So if they come to me with an amount that's not really kind of brings dignity to the value of mediation, then you can always go back to say that this might be just enough for the preliminary stages. And if you see value in mediation after the first two sessions, which are the preliminary sessions, are you open to then expanding that budget and bringing in more resources? So I guess that's one way of kind of doing it. I'm sure you'll have different ways of working with clients who are not really, not yet sure what they are ready to spend on this. I want to quickly go into the last bit, which is building an ecosystem for mediators to flourish. And in fact, Bill had a cue there for us to say that, we cannot be doing things for free, especially when we know that the parties can afford to pay. If you're in a commercial arbitration way or litigation where you have already invested so much, we know as mediators that they have the spending capacity. And so how do you build an ecosystem? What needs to be done to build an ecosystem for mediators to actually consider a full-time profession? India is still getting familiar with private pre-litigation commercial mediation, whereas the UK is quite familiar comparatively. So Bill, I'll start with you on this.
Yeah, thanks, Jonathan. I suppose the first thing I'd say is that to build an ecosystem is a collective effort. It's not just it's not mediators developing something and selling it. It's like we were coming up designing a new toothpaste or car that we're then going to launch into the market. It's because that is demeaning of the role of everybody else in the process, not just the users. So I think it's a collaborative effort right across society. That's to say, lawyers, judges, courts, government, mediators, users. And there are conversations that need to take place. We have something here called the Civil Mediation Council, and that has representation. It's a sort of overarching body for the field as a whole. That has representation on it from right across the spectrum: mediators, government, judiciary, users, and so on. And I think that's been very important. I think the other important aspect is stories. People sort of want to hear from mediators, except then mediators just say, understandably, well, I can't tell you because it was all confidential. What they really want to do is hear from people who've used it. And actually, if I think of the really interesting conferences that I've either been to or put on, they've been primarily where people who've used the process have said, this is what I thought beforehand, this is what happened, this is what I think now. So
Thanks.
those are two suggestions.
Awesome. Thanks, Bill. Chitra, over to you.
So to sort of put it in context for India, we have the court and ex mediation system, which I think is doing the most amount of mediations, I would hazard, are happening there. We also have a vibrant ODR institutions, and they have a network doing a lot of mediations again. I think some very huge volumes of mediations are happening there. And the third is, of course, private mediation, which anecdotally I think is picking up. I think what we would need to do is talk about stories, both from the point of view from the mediator talking about their story, anonymity preserved, but we have to talk about stories where we've settled. And this podcast is a great start for us to do exactly this. We must talk about settlements, we must talk about context, we must talk about difficulties and disputes and how they got resolved in mediation. That gives a sense of familiarity, a better understanding, and sort of a willingness. Because otherwise, we say mediation, settlement, and it sounds a little ephemeral. You know? So you talk and you settle. I think we need to talk more about the fact that there is structure to this. It's not just something you sit and talk and you're resolving. Plus about settlements that have been made. As well as parties speaking about it, users speaking about it. That's really important point that Bill makes. Someone has used it and they found value in it. Nothing sells like that. I think for India, we are at a certain cusp. We have this Mediation Act, and I think it has a lot of problems, but I think it's very useful in a few ways. The first is that it says that if you have a settlement agreement, it can be enforced as if it were a decree. That provides a lot of value to persons who want to try this out. No risk. You go through this process, and if you have settled, you can enforce it. There's a lot of value that is now added to this settlement agreement, as well as to the process. The second is the government announcing, and I think upfront in the act, they say that we will resolve our disputes using mediation. I think that's huge. The government is the biggest litigant, and they're saying that, we will use mediation. I think that adds a lot of credibility. The third is that the law also safeguards rights of parties fairly well. So, with all of this, I think this is a huge push for us now as mediators. We're now a very growing population of mediators, and work is scarce. And I think we've reached a space where we are, in competition with each other. I think in order to get mediation going and flowing in our country, we need to band together as either a state organization or a national organization, and we work sort of a little more strategically, a little more organized, a little more in terms of taking a certain approach to growing mediation that we apply in different parts of the country. And I think doing that, we're also going to be able to sort of reflect on what we want as mediators, how our process should be, what are the changes we need in our country, and how things are being done. Allows for a lot of reflection as well. And I think that's probably the most important thing for us today in India, to grow mediation.
And that's a very interesting point you made, Chitra, about the fact that in a small community that we have of mediators, at least those who are into the pop culture of mediation, is that we feel there's too much competition out there, or maybe it's saturated as a market. But the fact of the matter is that there are 54 million cases pending in Indian courts. So that's enough for all of us? And yet there is that struggle, because I believe we tend to live in our own bubble. We haven't really gone out there to the market. We haven't spoken enough about who we are and what we do. I think India is ready for mediation as a process. I don't think India is yet ready to recognize the mediator. And this statement that I make can be unpacked for the next whole hour. But what I'm saying is that I think we all love the process. Everyone says they love the process, but to find value in the mediator is something that we really need to work hard on as a community of mediators. This has been a fantastic conversation. Thank you for all who joined us live on LinkedIn and YouTube. And for those of you who will continue to watch this over the next few weeks and months and hopefully years. Hopefully, we have inspired you to start this conversation. These are the first steps. And of course, it's been an absolute honor to have Bill Marsh and Chitra Narayan with us on this first episode. I just want to hand it back to the both of you, actually, if there are any concluding thoughts to all mediators, users, and every other stakeholder who is contributing to this mission mediation.
Chitra, do you want to go first this time?
You're on mute.
Yeah, to all everyone who's listening. I beg your pardon?
I bounced you into that. I'm sorry.
Yes, you did. Yeah, so to everyone listening, I think these are just examples of, the great potential that mediation gives. I mean, the example that Bill gave, I think, of this huge dispute, difficult situation, a lot of trauma, and that mediation helped, get a resolution for a huge number and for a very deep trauma. I think tells us what we can do with mediation. So do try it. Bill?
Thank you. I'll end on a note, I think, that picks up Jonathan's point about whether India is ready for mediators as opposed to mediation. I must have had at least 6 mediations involving Indian parties who have come to London. Now, that's nice. Thank you very much. But that's not right, is it? Come on. These people should be finding their mediators in their own country. Of course, it's always an honor to be involved. But I think that example, I think, puts a finger on the point Jonathan was raising. And I tell you, when we started here, people went to the States for mediators because they said, yeah, but I mean, the mediators in America have got more experience. So it's a natural course. Now people don't do that, and I'm quite sure it won't be long before people in India are looking more to Indian mediators than they are to London. I certainly hope so.
Thank you, Bill. Thank you, Chitra. Nisshant, thank you so much for being a fantastic co-host, just how you've been for the last 10 years with me on this Mission Mediation at the Pact. This has been fantastic. We're going to meet in a couple of weeks again, another Saturday, and follow the Pact LinkedIn page. Please subscribe to the YouTube page. That way, you'll just get even if you have missed it out, you can always watch it while you're free on a Sunday or a Saturday. That's how the subscription button works. But thank you so much for joining us. This is just a start. And to answer the rhetoric question, yes, mediators are actually mediating. And we're going to hear more about that on the next episodes as well. Bill, Chitra, thank you so much for joining us today.
Thank you.
Thank you, Nisshant.
Thanks so much. Thank you.